Hello everyone, it's Harry Sherrod here and welcome to video number 7 of my foundation course in employment law, and today I'm going to be talking to you about flexible working. So the first point to make is it's not just about mothers or parents of young children. It used to be, but now it applies effectively to all staff. Next point is it can apply to any arrangement, so it's not just simply working part-time. It could be working at home, it could be working variable hours, it could be any arrangement that the employee wants to propose. And that is the next point. It is just a proposal, it's a request, and the employer can potentially turn down a request for flexible working on various business grounds. Now let's have a look at a case study, and what I suggest you do to make things a little interactive is it's a two-part case study. When I read out the first part, maybe pause the video, have a little think about it, scribble a couple of notes, then start the video again, and I will go through the answer, and then we can do the same thing in part 2. So here comes part 1 of the case study. Two employees in the same department have applied for flexible working. They both want to take Friday off. We can accommodate one but not two. What should we do? I think in this situation there's a reasonably straightforward answer, and I would apply the old-fashioned principle of first come first served. So you go through the first application, and if you grant that person the application to take Friday off, you go to the second person. You can then say, we're already an employee down on Friday, we're short-staffed, therefore we have a business reason, and on that basis we're declining your request. That should work okay. So let's now go on and look at the second part of the case study. The second employee to ask is the mother of a young child. The first employee to have asked is a 60-year-old male who wants to spend Fridays playing golf. Does this change the answer? Now, it's not part of the procedure for an employer to give a judgment on the merits of the reasons for the employee wanting to work flexibly, and it's actually quite a dangerous territory for the employer to start to navigate. You might be thinking, well, if I don't treat the mother of the small child favourably, could that be sex discrimination? But on the other hand, if you treat her favourably, the male is likely to say, I am an older male, so therefore it is age and sex discrimination to treat me less favourably and to be biased in favour of the female. So that clearly is a situation that the employer would like to avoid. So the solution to part 2 is in fact negative. It's no change to the process. You're still much safer to apply the first come first served approach to deciding between the two employees, and avoid making a value judgment as to which application carries with it the most merit. So I hope you have enjoyed that and found that interesting. That concludes this video, and I look forward to speaking with you again next time.